want to check, is there any law in India for witness protection, or was it only the Supreme Court? And what sort of witness protection was it? Was it relocation or just personal security?
The Law Commission of India, which is supposed to be the body that suggests reform in the legal system, has recommended since 2004, it's been recommending witness protection ever since the Best Bakery case and all that. And there are 3 or 4 schemes before the government, but no scheme has been put into place. As of now, we don't have a witness protection scheme in operation in India, though the debate is there, hovering at the edges, but the government does not want to bite the bullet, let's see. We have tried in that scheme, because many of us appeared before the Law Commission and all, we tried to look at the South African model, we tried to look at the Canadian model and see what is best suited to our conditions, because we have a certain societal conditions, etc. So what would be the best form? As of now, what we have in Gujarat in place is not relocation, except for those who wanted it. About 4 or 5 witnesses actually wanted to be relocated. Most of them wanted to stay back because it was a question of livelihood. People can't leave their locales easily because you're earning money there. So the issue was that they had cluster protection. They had cluster protection at their place of residence, and they had available escorts whenever they went to difficult areas of work. If they wanted to take it every day, they could, or they could take it whenever they anticipated problems. Because here you have daily wage earners, painters, carpenters, basically daily wage earners. So it was basic, but those chowkis are posted there day and night. And there are 18-20 men of the CISF available for this entire group of witnesses in every village. And they are central paramilitary. That's the other important thing. They are not Gujarat police, because that's the other thing we got from Supreme Court, that we didn't want the Gujarat police protecting them, because that would be the surest way of frightening them off. So it's CISF protection. CISF, which is Central Industrial Security.
Ma'am, you're talking about that state is definitely the largest prosecutor in our country. But if we see, you're talking about even that amendment to the CRPC, Criminal Procedure Code, Section 2482, in terms of which we can have victim survivors can have, independent lawyers also. But if we see the scope of those lawyers, that is so limited that even the prosecution which is carrying on the case in the court, they does not allow them even to, venture into the trial as a major part. But there was a case, perhaps Subramanian Swamy, he filed that 2G spectrum case, in terms of which he filed an application perhaps in the Supreme Court, I don't remember well, wherein he was seeking that he be appointed as a special public prosecutor, because the CBI perhaps did not allow him to prosecute the case properly. What is your take on that? Is there a possibility that we can have a kind of a special public prosecuting system, so that these victims survivors
already have? What Swamy was depending on is an existing provision of the law which allows for special prosecutors to any day be appointed. He was asking that he should be appointed, okay, but that system still exists. Even today, if a certain sensitive case is being handled, the state always appoints a special prosecutor. That's not a difficult thing. The question is who gets appointed.
That is for the state. I'm going to say in terms of, for example, you are assisting the prosecution in Gujarat cases.
Yeah.
Therein you are sending your own independent lawyers.
Yeah.
But I see that their scope is very limited. Is there a possibility that other than the state, can we have the appointment of special public prosecutors? That is my point actually.
Who appoints them? See, either it's the state or the court. Yeah. The way we had it is either the state appoints the prosecutor.
The state will definitely not agree on appointing special public prosecutors.
That is the time when you go to court. There have been many times when the state doesn't agree to appoint a special prosecutor, when people have gone to court and got appointments.
I want to know what is special, that particular provision in terms of which we can have the court can appoint. Is there?
That's the power of the court.
The provision is there in the Prevention of Corruption Act, under which he filed this case, the Swamy case.
Apart from that, in the Jayalalita case, in the Gujarat case, the court has supreme power to direct the appointment of a public prosecutor, and they've done it. They've done it in the Dalit killings cases. They've done it in Gujarat case. The point is not that. The point is that the 2482, I don't agree, is limited. If you look at it, that it's new jurisprudence being created. It's under 372 of the CRPC. Please look at it. There are 5 High Court judgments who are saying that the victims can appeal even if the state has not appealed. So it is limited compared to what we ideally want, but it's a huge breakthrough compared to what we had so far. So there's a Punjab High Court judgment, there's 2 Bombay High Court judgments and 1 Gujarat High Court judgment under 372, which actually said that even before state filed an appeal, we were allowed to file our appeal, which is giving us much more rights than the state ever before. It's a new thing, I mean, so that it's new jurisprudence. You have to look at these judgments. And that brings me to the Varun Gandhi case, which is what I wanted to end with today, is that Varun Gandhi's case is a very unique case of hate speech. In 2009 elections, I don't know how many of you are aware, in 2009 he was fighting the elections from Pilibhit in Uttar Pradesh. He made a disgusting speech. He said, I want to, Muslims are like vermin and insects, I want to get each Muslim gunshot and killed, etc. That speech was taped, it was telecast on national television, and many people took objection to it, okay. That time Mayawati was in power in Uttar Pradesh. She wanted to get political capital, so she filed an FIR immediately and launched the prosecution. That was in 2009. Then in 2012 we had a change of government in Uttar Pradesh. Akhilesh Yadav came in, and we were monitoring this case because we had complained to the election commission about it, etc. So we were monitoring this case. Sometime in June 2012 we got the feeling that the Akhilesh government is going to compromise and going to let the case go. So we immediately wrote to the Chief Minister and otherwise not to let this happen, and we started intervening in the court. We intervened in the court. We said that this is a public case. If somebody says this comment about a Muslim community, anybody believing in secularism is upset and we want to intervene. The court allowed us to intervene, and the magistrate heard us out but rejected our application. And Telka did a sting operation. I don't know how many of you are aware. 84 witnesses were turned hostile. 84 witnesses were turned hostile. The Muslim MLA of belonging to Samajwadi Party was the conduit used by Varun Gandhi to turn the witnesses hostile. It's a whole sting operation by Telka. It's available on the net. Anyway, that's the story. Finally, we got the information from Telka, we got the tapes from Telka, and we filed another application in appeal. Appeal went from magistrate court to sessions court. At that point, 372 was heard, and our appeal was filed first. We filed appeal, Awami Muslim Council and CJP together filed the appeal, and the judge said, how can they allow your appeal before the state has not filed an appeal? So we showed them all the judgments of 372 and he admitted our appeal. So my point is, it's a new jurisprudence that even the lower courts are getting used to. So it's not something that is well known. But coming back to Varun Gandhi's hate speech, now the hearing is on September 17th of this year. So the compromises that political parties make, because he's a big player now in the BJP and all, and even Mulayam, who talks about a secular vision, is allowing him to get off. So unless you have independent intervention by citizen human rights groups, minority rights groups, you're not going to get justice, because the political parties are looking for a wider compromise all the time.
We understand, I kind of understand the word communal violence, but if you could help me understand this word communal only.
See, that's a word. If you understand the word communal, it can be confusing, because communal in the Western sense means communitarian. It depicts community, which is why I started off by saying that communalism has been recognized by historians to mean manipulation of religion and religious symbols for political ends. So I can define communalism for you. I can't define, and what is communal comes from the conduct of communal politics. So I find an act a communal one if it is such a partisan act. If it is deliberately misusing an identity, whichever that identity, for political gain. So you're not against religion per se, but of its misuse politically. Sorry. Was that hand?
No.
Yes. Sure.
Since we know that, in appeals we have very limited scope, we cannot go for a retrial. We cannot get it.
You can.
You see, we cannot get witnesses once more to the court.
Of course you can. We got it in best faith. I'm saying that you're looking at the law very limited. Mm-hmm. We got it from Supreme Court. You can get retrial, you can get reinvestigation, you can get further investigation. It's a question of combining sections. There's not just 372. The trial court under 311 has the right to summon any evidence. The courts are not doing their job. It's your job to point out they're not doing it.
Thank you.
The laws exist. We don't know how to invoke them properly. And always try and invoke them at the lower level. Don't try and invoke only at the High Court and Supreme Court level. Because that's another mistake we make. Strategically, you should start from the bottom, not from the top.
Well, thanks, Tista, and we move on to the response of the courts in South Asia. Hello?
Just a break for tea for another 15 minutes. Get back and